He looked at me across that boardroom table and told me I was just a cleaner, and that I needed to get out before the client saw me sitting there. 3 weeks later, I stood in a federal courtroom, and the same judge who was about to throw me out of that room called me ma'am, in front of everyone, the moment he read my name off the docket. My name is Eleanor Voss. Most people at Kingston and Marsh Consulting only knew me as the woman who vacuumed the 32nd floor after everyone else had gone home. I emptied Bradley Kingston's trash can every night for 8 months. I straightened the chairs in the exact conference room where, 3 weeks later, he would humiliate me in front of a client and a room full of junior staff. I want to be honest with you about something before I go further. I was not always a cleaner. I spent 31 years doing something very different, something none of them at that company ever bothered to ask about, because to them, a woman pushing a cart of spray bottles at 11 at night was not a person worth a single question. That night, before any of it happened, I was folding a stack of clean towels in the break room when I heard Bradley's voice down the hall, sharp, already annoyed at something that had not even happened yet. I did not know it then, but that was the sound of a man about to make the worst mistake of his career. Bradley Kingston ran the Chicago office like it was an extension of his own reflection. 3 framed magazine profiles hung outside his door. He corrected people's grammar in Slack messages, and once sent a company-wide email about the proper way to load a dishwasher in the break room. Everyone smiled at him and complained about him the second he turned a corner. The morning it happened, there had been a scheduling mix-up. Facilities used a shared shift app to reassign rooms, and a client walkthrough had bumped my usual slot an hour earlier that morning. The app sent the update to my supervisor's account instead of mine, a known glitch nobody had bothered to fix, so I walked in with my cart at exactly 10:15 to wipe down the table before the next booking, the way I had 100 times before, with no idea the room was no longer empty. Except this time, Bradley was already seated at the head of that table, and across from him sat a client from a logistics firm in Ohio, a man in a gray suit who had flown in that morning. 6 junior associates lined the far wall, laptops open, waiting for Bradley to make a good impression. I said I was sorry that I would come back, and I turned toward the door. That should have been the end of it. Instead, Bradley stood halfway out of his chair and said, loud enough for the hallway to hear, "You're just a cleaner, you don't sit in my meetings, get out." Not asked. Not corrected, quietly. Announced like he needed an audience for it. The room went quiet the way a room does when everyone sees exactly what just happened, and nobody has the nerve to say so out loud. The client from Ohio looked down at his phone, embarrassed on Bradley's behalf without realizing it. I nodded, picked up the spray bottle I had set on the table and walked out. I did not argue. 31 years of experience had taught me that the smartest move in a room like that is not the loud one. But at the end of that hallway, near the elevator bank, a young HR associate named Marisol Reyes had just stepped out of the stairwell, and she saw the whole thing land. Marisol did not say anything to me that day. She simply watched Bradley walk back into his meeting, straightening his tie like nothing had happened, and she pulled out her phone and typed something into a note before she even reached her desk. I did not know it yet, but she was the only person in that building who thought what she had just seen was worth remembering. I went back to the break room, finished folding the towels, and told myself it was nothing. I had been dismissed by men with far more power than Bradley Kingston. But something about the specific phrase he used stayed with me longer than it should have. Just a cleaner. As if that was the entire sum of a person. Word of the boardroom incident moved through the office the way these things do, quietly, in Slack threads and hallway whispers, until it reached someone in senior leadership who mentioned it to Bradley almost as a joke. Bradley did not take it as a joke. His name had come up 2 weeks earlier for a partner track review, and the last thing he wanted circulating upstairs was a story about him losing his composure over a cleaning cart. Within a week, my hours changed without explanation. I went from the reasonable 8 to 11 shift to the 11 p.m. to 4 a.m. block. The one nobody wanted, the one that meant 3 buses home in the freezing Chicago dark. When I asked facilities why, I was told it came down from upstairs, no further detail given. A janitorial coworker named Ruth pulled me aside near the supply closet that same week and told me quietly that she had overheard someone in HR mention my name and the word documentation in the same sentence. She did not know what it meant. Neither did I, not yet, but it was the first time I understood that whatever was coming had already started before I ever saw it. Then came the staff meeting. I was not even supposed to be in that meeting, but I had been called in briefly to confirm a supply closet inventory, standing near the back with a clipboard. Bradley, mid-presentation, made a comment to the room, something about how certain people in this building don't understand their place, gesturing loosely enough that everyone knew exactly who he meant. A woman who mops floors and doesn't know her place, he said, and two junior associates actually laughed, not because it was funny, but because laughing felt safer than staying quiet. I stood there and said nothing because I had learned a long time ago that dignity is not the same thing as a reaction. But that night I asked Bradley directly, calmly, if we could speak privately about how I was being treated. He agreed to the meeting. He did not agree to the conversation I expected. 2 days later, I was handed a formal performance improvement plan, the kind of document HR uses to build a paper trail before a termination, citing attitude concerns and insubordination, neither of which had ever appeared on any review of mine in 8 months. I read it twice and I recognized the language immediately, the phrasing of a document built to survive a lawsuit rather than describe an actual person's actual behavior. Someone had written this to be defensible, not accurate. Marisol was the one who processed the paperwork, and I watched her pause over one line for a long moment before she looked up at me. She did not say much, only that she had flagged something about the timeline to her supervisor. Her supervisor's response, she told me later, was short. He said Bradley brought in more revenue in 1 quarter than the entire facilities department combined, and that some fights were not worth having. 3 days after the performance improvement plan, I was terminated. At Will Employment, they told me they did not need a specific reason and technically they did not have to give one. I sat across from a facilities director I had spoken to maybe 4 times in 8 months while he read from a printed script, and at the end of it, he slid a termination letter across the table, along with a small envelope containing my final paycheck stub and a note that my badge access had already been deactivated as of that morning. Picked up the pen. My hand did not shake, which surprised even me a little. I had been fired before, once decades ago, under circumstances far more complicated than this one. I knew the shape of injustice well enough by now to recognize it immediately, even in a small windowless office with fluorescent lighting and a box of tissues nobody had touched. Before I signed anything, I asked to review the paperwork one more time, out of habit more than anything else. Near the bottom of the packet was a standard notice about my rights under federal equal employment law. The kind of boilerplate every company attaches to a termination file without much thought. There was an error in it, a citation referencing the wrong subsection entirely, the kind of mistake a lawyer would catch in about 4 seconds and everyone else would scroll past. I picked up the pen sitting on the table and corrected it myself in the margin, without really thinking about why I knew that citation by heart. Marisol noticed. She asked, almost joking, if I used to work in HR somewhere. I told her no, and I said something under my breath that I did not expect her to remember, that at will employment does not mean employment without cause, it just means the burden of proving the cause falls somewhere else. She wrote it down anyway, in the same notes app where she had logged the boardroom incident weeks earlier, though at the time, neither of us understood why it mattered. I signed the termination letter, thanked her for her patience, and walked out of that office into a parking lot lit by a single flickering street lamp, carrying a small cardboard box that held 8 months of my life inside a building that had never once asked who I used to be. I did not intend to sue anyone. For 3 days I genuinely considered letting it go, telling myself I was too old to start a fight I might lose in front of a courtroom full of strangers. I filed the complaint with the Equal Employment Opportunity Commission mostly because Marisol encouraged me to, and because the pattern once written down in order, looked far worse on paper than it had felt living through it day by day. A retaliation claim, layered under a wrongful termination filing, moved further and faster than any of us expected. Kingston and Marsh's legal team assumed it would settle quietly, the way these things almost always do. Their attorney, a sharp, confident man named Grant Pelletier, requested it proceed as a formal hearing instead of mediation. He was betting on an easy win. He said as much to a colleague in the hallway, not worried about this one at all. I arrived at the federal courthouse in downtown Chicago in the same plain gray coat I wore to work every night. Pelletier and 2 associates walked in ahead of me in tailored suits, discussing strollers and school districts. Bradley sat 2 rows behind them, arms crossed, visibly annoyed at having to be there. I sat at the plaintiff's table alone. Marisol had come as a witness, seated in the gallery, twisting her hands in her lap. The room made its usual assumption about me. Nobody looked twice. The bailiff called the courtroom to order. Pelletier stood first, addressing preliminary matters with the easy rhythm of a man who had done this 100 times. He described me, without using my name at first, as a well-meaning but overmatched former employee bringing an emotional grievance dressed up as a legal one. Then the courtroom door at the side of the bench opened, and the presiding judge walked in, files under one arm, reading glasses already halfway down his nose. He sat, adjusted his microphone, and began reading the case number and the names of the parties involved out loud, the way judges do every single morning without a second thought. He got through the first line normally. Then he reached my name and he stopped. He did not stop for a second and continue the way a person does when they trip briefly over a syllable. He stopped completely, one hand resting flat on the folder in front of him, his eyes lifting from the page to scan the room until they landed directly on me. Pelletier noticed the pause and glanced sideways at his associates, unsure whether something procedural had gone wrong. Bradley, 2 rows back, simply looked annoyed at the delay, checking his watch like it was costing him something personal. The judge removed his glasses entirely. He said my name again, slower this time, and asked, with a formality that did not match the flat administrative tone he had used 30 seconds earlier, whether I was the same Eleanor Voss who had once sat on the federal appellate bench in the 7th Circuit. The room did not understand the question yet, but I understood it completely because I recognized him too, a much younger version of the man now sitting in that chair. A clerk I had trained personally more than 15 years earlier, back when clerking under me had meant 12-hour days and no patience for sloppy legal reasoning. I answered him plainly. Yes, I said, that was me a long time ago, before I stepped away from the bench for personal reasons that had nothing to do with my ability to do the job. I told him I had spent the years since then choosing to be left alone, and that choosing to clean an office building at night had strangely given me exactly that. Pelletier had gone very quiet. Marisol, in the gallery, sat forward so fast her chair scraped audibly against the floor. Bradley had stopped checking his watch entirely, his face going slack with a kind of confusion he clearly had no idea what to do with. The judge, Thomas Whitfield, addressed me the way he would have addressed me 15 years earlier in chambers, with a level of formal respect he had clearly not planned to use in a routine morning docket. He called me ma'am, and something in the way he said it carried the weight of every argument he had ever lost in front of me as a young clerk trying to prove himself. Judge Whitfield explained to the room, briefly and without elaboration, that I had served on the federal appellate bench for 11 years before retiring early, and that during his clerkship, I had a reputation among every attorney who appeared before me for catching exactly the kind of technical omission that a lazier legal team hoped would slip past unnoticed. Then he paused and said something that shifted the room a second time. Given our prior relationship, he said, he would need to consider on the record whether he could remain the presiding judge on this matter at all, and he asked both sides to weigh in before he ruled on his own recusal. For a moment, nobody in that courtroom knew if the hearing would even continue under him, and I realized, watching Pelletier's face, that he had gone from expecting an easy win to not knowing what he was fighting anymore. Pelletier's face did something I had seen many times across a bench, a confident man quietly recalculating everything he had said in the last 10 minutes. He glanced down at his own complaint response, the one describing me as unsophisticated and overmatched, and I watched him understand exactly how badly that phrase was about to age, regardless of who ended up on the bench. Bradley leaned forward and whispered something to Pelletier, and Pelletier did not whisper back, because there was nothing useful left to say. The associate beside him began flipping through their file with visibly shaking hands. Both sides declined to request Judge Whitfield's recusal, agreeing on the record that his past clerkship did not create bias against either party, only history. He accepted that, and the hearing continued. During the recess that followed, Bradley approached me near the hallway water fountain, and for the first time in 8 months, he did not sound superior. He said he did not realize that if he had known, things would have gone differently, and I told him without raising my voice, that the way he treated people should never have depended on who I turned out to be. He had nothing to say to that. He walked away toward the men's room, and I noticed his hands were not entirely steady either. When the hearing resumed, Judge Whitfield allowed the case to proceed on its full merits, and I walked the court through the timeline myself: the boardroom incident, the shift change, the staff meeting comment, the performance improvement plan built from language designed to survive exactly this kind of scrutiny, and the termination that followed 3 days later. Marisol was called to testify. She described what she had witnessed in the hallway that day, and when asked whether she had documented concerns about the termination paperwork at the time, she confirmed it, reading directly from the note she had saved in her phone the same week it happened. Her supervisor, seated in the gallery, would not meet her eyes. Pelletier attempted to argue that the termination was performance-based, unrelated to the earlier incidents, but the timeline did not support him, and Judge Whitfield said so plainly, noting for the record that a performance improvement plan appearing 3 days before termination, following 2 documented incidents of public humiliation, painted a pattern that did not require much interpretation. Kingston and Marsh's general counsel, watching from the back of the gallery, requested a private conference with Pelletier before the afternoon session even began. 2 weeks later, I sat across a mediation table from the firm's general counsel, who slid a settlement agreement toward me that included full back pay, coverage of my legal fees, and a written acknowledgement of retaliation entered into the record, not just a check and a handshake in a hallway. Within a week, Bradley Kingston was no longer employed at the company that still carried part of his family's name on the letterhead. Marisol later told me his office was cleared out on a Friday afternoon while most of the staff were still at their desks. No announcement, no send-off, just an empty corner office by Monday morning. Separately, the firm reached out to Marisol regarding her role in surfacing the retaliation pattern, an outcome she had not expected and had never asked for. I was offered, informally, the chance to speak with a legal placement firm about returning to some kind of judicial or consulting role, and I said no the same way I had said no to Judge Whitfield's private thank you outside his chambers a few days later, when he told me that watching me handle that courtroom reminded him what real judgment actually looks like: quiet, unshowy, built on character rather than title. I chose instead to spend time mentoring Marisol, who was considering law school now, encouraged by a woman she had only known for 8 months as the person who used to straighten chairs in a conference room after everyone else had gone home. We meet most weeks at a diner near her apartment, and she asks better questions than most of the attorneys I used to supervise. I still remember walking out of that courthouse in the same plain gray coat I wore in, and this time the people in the hallway looked at me differently, not because my coat had changed, but because they finally understood what had been standing in front of them the entire time. If this story meant something to you, share it with someone who has ever been underestimated for the wrong reasons. And if you want more stories like this one, subscribe, because there are more people out there just like Eleanor, waiting quietly for someone to finally ask the right question.